This is an appeal in the matter of Gibson and TSE Malta LP.
Good morning, my lords. I appear with my learned junior, Mr. Mitchell, on behalf of the appellant, Mr. Gibson, and my learned friends, Mr. Davis Jones, KC, and Miss Tulip and Miss Airy appear on behalf of the respondent, Betfair. Your lordships will have seen that there are 3 grounds of appeal, and before I start with my first ground, I thought I would offer some signposting as to how I was proposing to address those. So I was going to address them in turn, of course. And in dealing with ground 1, I was going to take your lordships first to the legal framework, looking at the Gambling Act and the codes of practice, the LCCP as they've been called, before I offer my first proposition as to the minimum requirement set by the LCCP. Then I was intending to address ground 1, dealing with the test for overturning factual findings, and then offering my second proposition as to the judge's finding in respect of the defendant not being in breach of the LCCP, being incoherent, irrational and or plainly wrong. Then, my lords, I was going to move to ground 2, the duty of care ground, address you first on the existence of a duty of care, and my third proposition was to be that there is a duty of care in this case. Then to address you on breach, very briefly, the fourth proposition being there was a breach. The fifth proposition, my lords, relates to causation, that if a duty exists and if breach is made out, that breach caused the loss claimed by the claimant. And finally, my lords, I was going to deal with ground 3, the question of whether contracts in breach of the LCCP are void. And my sixth proposition was going to be that they are. So grounds 2 and 3 raise some interesting points of legal principle, but I recognise that if my client doesn't succeed on ground 1, any submissions I make on grounds 2 and 3, whatever impact they may or may not have on the law.
Yeah, I was going to say grounds 2 and 3 only run if you're right on ground 1, don't they?
Yes,
so you really need to focus on ground 1.
Yes, my lord, I was intending to. So, my lord, in that case, allow me to start with my ground 1 submissions. First of all, the legal framework. So if I could take your lordships first to the Gambling Act. Now, there's been a slight, I'm not sure if your lordships have hard copy bundles or whether you're operating.
Well, I've got both of them, but hard copy for me.
So there's a little bit of an issue with the numbering, so I'm going to have to read out 2 page numbers. The hard copy numbering is consecutive through the bundles. The opus numbering is not consecutive, it restarts at every tab. Right. So the bundle and the tab number remain the same, the page number will be different, so I shall have to give out 2 page references, one for those using hard copies and one for the EP.
So we've got the Gambling Act and the Authorities Bundle at tab 1.
Yes, my lord.
Which sections do you want us to go to?
So my lord, I was going to rattle through a few. So on the first page, section 1(3), just draw to your attention, one of the 3 licensing objectives under the Act is to protect vulnerable people. Going forward to page 9 of the hard copy and opus. Section 13, a betting intermediary is caught by the Act, and that's a person who provides a service designed to facilitate the making or acceptance of bets between others. And then page 14, section 20 refers to the setting up of the Gambling Commission. Page 16, section 24. This deals with the codes of practice. And I just underscore in sub-paragraph 1 is a mandatory requirement for the Commission to issue codes of practice. And 2, code shall describe arrangements that should be made by a person providing gambling facilities for the purposes of, and B refers to protecting children and other vulnerable persons who are being harmed or exploited by gambling. 8 said, which my learned friends rely on, says a failure to comply with the provision of the code shall not of itself make a person liable to criminal or civil proceedings. But this subsection is subject to any provision or by virtue of this act making an exception to the offence. Now, my learned friends argue that kills off any argument I might try to raise about a civil claim for breach of duty, or any kind of civil breach of duty. I submit it doesn't. I would acknowledge that section 24, subsection 8, would kill off any argument for a claim of breach of statutory duty. That's what it's saying. It's saying any breach of the code will not of itself give rise to civil liability. So breach doesn't give rise to the tort of breach of statutory duty. But subsection...
It must go further than that, mustn't it? I mean, any failure to comply with a code doesn't of itself give rise to civil proceedings. So I mean, one wouldn't naturally construe that as meaning if you want to try and impose a civil liability, you're going to have to find something other than the breach of the code.
I would agree to a point, my lord. I'd agree you'd have to show something more than just a breach of the code. But I'd submit that the breach of the code must have relevance, otherwise subsection 9 doesn't really make sense. Because subsection 9 says, but a code shall be admissible in criminal or civil proceedings and shall be taken into account by a court or tribunal in any case in which appears to the court or tribunal to be relevant. So in my submission, my lords, the Act is countenancing a situation in which the code may be relevant to a claim for criminal liability or civil liability. So I would accept the proposition that a breach of the codes in itself will not give rise to a civil claim. One must show something more, but I submit the door is not shut on civil claims. From there, if one goes to page 19, sections 27 and 28, they set out the Commission's role in assessing compliance and pursuing offences under the Act. Page 22, section 33. And this provides that a person commits an offence who provides facilities for gambling unless one of the exceptions is set out. And one of those at subsection 2 is holding an operating licence and carrying on your activity in accordance with the terms of that licence. So if one provides facilities for gambling in a way that is not in accordance with the licence terms, that provision is unlawful and one commits an offence. And the offence under subsection 4 refers to summary conviction to imprisonment for a term not exceeding 51 weeks, a fine not exceeding level 5 on the standard scale, or both. And the fine, as from the 13th of March 2015, is an unlimited fine. And I will submit in due course that may be of relevance with one's looking at the consequences of a contract being entered into in breach of the codes and breach of section 33. My lords, if one goes forward to page 30, let me just for your note. We have there protection of children and young persons. Section 45 defines child and young person. Over the page 46 makes an offence if you invite, cause or permit a child or young person to gamble, unless you fall within one of the exceptions. Go forward to page 39. Section 62 sets out the penalty if you commit a gambling offence in respect of a child or young person. Page 41, provision dealing with the nature of the licence. Page 55. Section 82, compliance with code of practice. And this provides that a mandatory requirement that an operating licence shall be subject to the condition the licensee ensures compliance with any relevant social responsibility provision of a code of practice issued under section 24. Page 79. Section 116, this is a review by the Commission of how licensees are conducting their activities. And then from there, over the page section 117, sets out the regulatory powers that are available to the Commission having carried out that review, and they span over sections 118 to 121. They run through various sanctions from suspension to revocation and a financial penalty. And my lords, if you go forward to page 94. Section 334 repeals earlier provisions, earlier Gaming Act provisions. Section 335 sets out the enforceability of gambling contracts. They won't be unenforceable merely by virtue of being gambling contracts.
Well, those sections repeal all those sections in the old Gaming Act which made gaming illegal.
They do.
Or made the gaming contracts void and unenforceable.
They do, my lord, and there's going to be obviously a discussion as to what that impact has on the submission I make in due course under ground 3 about contract void.
Well, it makes it difficult, I think.
And my lord, section 336 is the power of which the learned judge placed some reliance on in respect of our ground 3. And this is the power of the Gambling Commission to void a bet if it's satisfied that the bet was substantially unfair. I'm going to submit that doesn't really move the needle on my argument as to contracts being void, because it's dealing with a slightly different mischief. It's a contract that would otherwise be valid, otherwise in accordance with the LCCP, but substantially unfair. So I submit that's a slightly different point. My lords, from there, if I could take you to the white paper. This was the government's white paper before producing, before the Act was passed, and that is in the authorities bundle. If you're using the hard copies, it will be A3 Part 2, tab 49.
Section 336, sorry, just looking at it. That's a sort of restitutionary provision. You get your money back. So you get back what you've outlaid, but you don't. It doesn't say you make the operator with the license has to restore the financial position ab initio, does it?
Well, let me. I don't think it does specifically say that, my lord. It refers to the power to render the bet void, and then the question is what follows on from that will of course be maybe a separate question of whether a restitution remedy lies.
Sorry, the criteria for voiding a bet are that the Commission must be satisfied it's substantially unfair. Is that right? And
Yes.
Can that include because someone's a problem gambler or not?
It doesn't appear to.
No. So that's not a power that is intended to deal with voiding bets with problem gamblers.
Okay. Sorry, Mr. Cook, you were going to show something else now.
I was going to take your lordships to the white paper. So that is
Which tab's that?
that's bundle A3, second part. I understand your lordships have these in two parts. It's bundle A3.
Yeah.
Tab second part of it, tab 49. And the hard copy page 1535 is the first page, opus page 1.
Okay.
So this is the government's white paper that led up to the passing of the Act. And the point I wanted to draw out of this document was that the sections dealing with protecting vulnerable persons were at the heart of the intended legislation from the outset. So if we could turn to page 1538, opus page 4. There's a foreword. I don't invite you to read all of it. Under the highlighted section.
Opus is looking at something completely different.
This should be tab 49.
Sorry, it's tab 49. So it's the authorities bundle, tab 49. Yes. And page 4. Thank you.
Right.
So in the highlighted section, there's a reference to encapsulating key objectives, wanting gambling to be safe. Gambling must continue to operate within a regulatory framework that offers protection for children and vulnerable adults. And if one then goes on to the following page, this refers to the social climate having changed, and there's a powerful case for lifting regulatory burdens on an industry which has built a world reputation for integrity. But at the same time, a careful judgment has to be made about where the new balance of regulation should lie. It's all about making a careful judgment in that regard. And as I'll show your lordships in a moment, between the white paper and by the time the Act was passed, that balance had moved even further in the direction of protecting vulnerable persons. So there were changes made between the original Gambling Bill and the Gambling Act that was passed. If one goes from there to page 1549, paragraph 4.1. Sorry, page 15 for Opus. No, tab 49, page 15. And it's just the highlighted section in paragraph 4.1. And if one goes on to page 1565, Opus page 31. Dealing with the downside, the social responsibility piece, paragraph 7.2 refers to particular risks to children, the vulnerable, and further on about providing proper controls and protections for those who may be or already have been damaged. And is a reference to an estimate which the paper describes as not yet reliable, but somewhere between 275 and 370,000 problem gamblers at any time. And just in respect to my point as the balance moving from the white paper even further in the direction of vulnerable persons, I just ask you also in bundle A3 to turn to the following tab, which is tab 50. And that's page 1578, page 1 for Opus. This is the draft gambling bill. And if one goes forward in that to page 1596, page 19 for Opus. Tab 50, page 19. Under codes of practice, you'll see that the paragraph subpara 1 refers to a permissive. The Commission may issue a code of practice about the manner in which, etc. And your lordships will recall section 24, which I showed you, makes that mandatory. So that was the example I meant as to when one talks about where the balance should lie between allowing happy gambling and trying to protect the vulnerable, the balance moved to make the codes mandatory. Next one was if I could show you the codes, the LCCP, and that will then lead to my submission.
Just before we get there, obviously we're going to come on to what's meant by problem gambling and so on, but what we get from the Act and from the white paper is the concept of protecting those who are vulnerable, and in 7.2 of the white paper, protecting those for whom the temptation to gamble to excess is very hard or in practice impossible for them to control. So it's impairment of control to to a level which is either very hard or impossible to control. Are those the key concepts we get out of that material?
Well, my lord, I'm going to come in a moment to what I submit problem gambling is supposed to mean on when one looks at all this. But it's essentially those that seem to be I'm going to be submitting in due course. Those that appear to be gambling beyond their discretionary income. Those would be the people that I submit one should classify as problem gamblers. But effectively, the codes at this stage are, and these general statements in the white paper are not actually condescending to detailed particulars. It's giving an overview of the direction of travel should be that those that seem to have problems with this should be in some way protected. That's all I seek to derive from that, my lord.
Thank you.
Yeah, okay.
So, my lord, if one goes to the LCCP,
Which is where?
that is in bundle S3, tab 3. Sorry, my lords. So for Opus, that's S3, bundle S3, tab 3, page 1 for Opus, page 115 for those in hard copy. And if one goes forward to page 118, Opus page 4, you see a general introduction.
Sorry, I haven't found it. Supplementary bundle part 3.
So yeah, bundle S3 supplement. It's
My supplemental bundle.
Yes, it'll be
part 1, part 2, part 3, part 4. Is that
that's right. So it should be the supplementary bundle part 3.
all right?
Well,
Page, I don't have any tabs in there.
Supplementary bundle tab 3,
Starts
bundle 3, part 3 of 5 is the evidence of somebody at the trial
Right. So
it
that,
starts at page
for
75.
the entire bundle.
I think what you want is what is tab 3 of S1.
S331. So I'm told the page number will be correct. It'll be page 115. I'm sorry, I'm not sure what's happened with your lordship's.
Right.
Well, it's in bundle, as my lord says, it's in bundle S1.
It's in bundle.
So
Tab 3.
Tab
of
3,
that- of
bundle
that.
S1,
Thank you.
115, licence, conditions and codes of practice.
Yes, my lord.
February 15.
That's the document.
Thank you.
And so these are the codes that we review that I should be taking to. And if one turns to page 118, we have general introduction. Paragraph 1 just sets out the Gambling Commission's general licence conditions and associated code of practice. Paragraph 2 refers to the parts in blue being the principal code of practice. And paragraph 6 refers to this version comes into force on the 8th of May 2015. Page 119, Opus page 5. Paragraph 3 refers to the protection of children and other vulnerable persons, and 3.1 refers to combating problem gambling, and the code then goes on to combating problem gambling. I submit that problem gambling fell within the concern and the definition of protecting vulnerable persons. If one then goes to the main provision that arises in our case, that's page 122. This is paragraph 3.4.
Yeah.
So betting exchanges, licensees, must put into effect policies that must include A to F. And they must do that where they have concerns that a customer may be a problem gambler. And so the trigger for the mandatory requirement to put in place policies and give effect to them is a concern that the customer may be a problem gambler. So that leads on to, well, who or what is a problem gambler? Now, there is no definition in the Gambling Act, and there is no definition in the LCCP. In the judgment, if I, we can turn it up, or I could just, paragraph 120 of the judgment, His Lordship referred to the British Gambling Prevalence Survey 2010's definition. And he defined problem gambling as a person who is gambling to a degree that compromises, disrupts, or damages family, personal, or recreational pursuits. So that was his Lordship, the definition His Lordship adopted at paragraph 120. Now, the British Gambling Prevalence Survey, the BGPS, and later Health Survey for England, who took over their role, had a published definition of problem gambler. So if I could ask you, my lords, to bring up bundle S7, supplementary 7, tab 1. So page 1400 or page 4. So the first page is the refers to the NatSen social research. And so if one goes to page 1400, which is Opus page 4. One has there some under background. It simply explains how the health survey for England took over from BGPS. If you go forward, my lords, to page 1403, which is Opus page 7. Yes, okay. And this, at the bottom of the page, problem gambling prevalence, defining problem gambling. And the first bullet sets out the definition that was referred to by the judge at paragraph 120. And the second bullet then states how estimates of problem gambling are arrived at using two instruments, DSM-4 and the PGSI. So those are the two different measures of instruments. And if one goes over the page, the first bullet refers to the DSM-4 instrument providing a score of between 1 and 10, and a score of 3 or more on that scale is used to define problem gambling. And the second bullet refers to the PGSI instrument, which provides a total score of somewhere between 0 and 27, and a score of 8 or more represents problem gambling. And
is that accurate, or are those definitions of a gambling disorder?
no, my lord, so I was going to come on to the distinction between the two. That is for problem gambling.
Right.
And one just sees that in the document. If one goes on at page 1413, Opus page 17. We see there a table setting out prevalence rates, and in about the first substantive row, you see the DSM score 3+, brackets problem gambler, and under that, the PGSI problem gambler score 8+. And just on this point as to the definition of a problem gambler, at trial, Betfair's witness, Miss Lawson, who had various roles in the responsible gambling team, agreed that these would be the screening tools that the Gambling Commission would use if it wanted to answer the question of who was a problem gambler. I'm happy to take your lordships to the transcript, but I can give your lordships the reference, and you can tell me if you find it helpful to look at that transcript or not. The reference is S6, tab 5, page 805. And as I'll show you in a moment, the Gambling Commission has also in its papers described a problem gambler as a person who's spending more than their discretionary income. And discretionary income is their disposable income after expenses. I'll show you where that's set out in a moment. And that idea of discretionary income being the touchstone to some extent seems to be close to how Betfair saw it in 2015. So if I could take you to...
Can I just understand something? You've just shown us definitions of problem gambling, which are behavioural, as far as I can tell. You have a score and you look at behaviours, you ask questions, no doubt, and you get a score. But now you've given us a completely different definition of problem gambling, which is relative to your income. So which is it?
So my lord, the DSM-4 and the PGSI scores are the if I could, the official quotes unquotes way to define a problem gambler. But as a practical method of how one would apply that, this was my alternative definition, my lord. There is ultimately, my lord, I'm going to submit that there is an element of common sense about it. One should know when one has data from someone that shows they are gambling in a way that is irresponsible or beyond their means. And the DSM-4 and PGSI criteria are the, I would call, official criteria. But
Was DSM-4 in force at the time, or had it been superseded by DSM-5?
It was in force at the time of the health England survey, so that became overtaken by DSM.
so it was in force at the time of the Health England survey, but then it was overtaken by DSM-5.
So it was DSM-5 that was the clinical test that was in force during the period we're concerned with, is that right?
Committing crime was removed as an indicator, everything else was the same.
I'm telling you, yes is the answer, my lord, but essentially they were materially identical, save that committing crime was removed as an indicator between DSM-4 and DSM-5.
Well, DSM-5 was looking at a gambling disorder. It wasn't looking at something which was defined as problem gambling. But have we got DSM-4? Was DSM-4 concerned with a gambling disorder or concerned with problem gambling as a concept?
They're both diagnostic, but it's got 3 or more near problem gambling, 5 or more via disorder.
So I'm gonna-
It was used as a clinical tool to diagnose. It was used by Health England as a screening tool with a score of 3+. So it was used in both ways.
So my lord, it was used in both ways. So it was used by Health England as a screening tool, but it was used clinically to help diagnose gambling disorders.
Taking it in stages. DSM, which is identifies a health disorder, was expressed, was it DSM-4 expressed in terms of a gambling disorder rather than using the expression gambling problem?
Yes.
And we got DSM-4 somewhere. Don't worry if you can't find it now, perhaps you can point us to it. And DSM-5, certainly, which I have looked at, talks in terms of gambling disorder.
Well, my lord, as I'll
And
be...
it's your submission, is it, that gambling problem, for the purposes of the LCCP, is synonymous with gambling disorder or not?
No, it's not, my lord. One of my submissions will be, or my submission is, it's important to distinguish between the two. Problem gambling and gambling disorder are two different parts of the same spectrum of severity. But a gambling order is more severe than problem gambling. So one needs more factors to be hit on a DSM-4, DSM scale and a PGSI scale in order to become to have a gambling disorder. And a gambling disorder is to some extent like a psychiatric diagnosis. So that may require a psychiatrist to go through the clinical process of diagnosing someone having a gambling disorder. I submit problem gambling does not require that psychiatric assessment. It is what one can assess that in my submission without medical evidence.
So coming back to where we were on this document, you're not submitting that although this document talks about problem gambling by reference to DSM-4, you're not suggesting that DSM-4 gives us our definition of problem gambling.
My lord, it's a definition of problem gambling. It's
Have we got it in the bundles?
The definition is the one you read out in the judgment. This is a screening tool that can indicate that someone satisfies that definition.
so my lord, the definition here was the first bullet point we looked at. It was quoted in the judgment. But the remainder of the document we were looking at is a screening tool to.
Well, we're told that if the score is above 3, the person in DSM-4 is a problem gambler. So where's it set out? So we work out what the score, how you get to the score of 3+.
So my lord, I don't believe we have so there are effectively questions that are asked. I will looking across to see if we have the questions in the bundle. I don't believe we do. But there is essentially questions asked that relate to how the gambling habits and the gambling urges of the person being asked. And on the basis of the answers to those questions, points are scored, and either you score low or you score higher. And from that, one can assess whether you have a
You can see them in Authority Bundle, tab 17, page 30.
Well, I think it's important that we know what your case is as to how you say Betfair should have assessed whether or not your client was a problem gambler. I mean, you say that they should have assessed him as a problem gambler. If
my
that's
lord,
right, then we need to know what criteria they were to apply and from whence they derived those criteria.
my lord, I will develop this. Just taking your lordship's point about is DSM-4 in the bundle?
Yeah.
One can find it in the authorities bundle. It's quoted on, and it's in the authorities bundle at tab 17, which will be A1, part 2, tab 17, page 34. So it's
in Calvert, is it?
It's Calvert, paragraph 1, 2, 3. So page 546 of the bundle.
Right, that's helpful. Thank you very much. Good.
So my lord, for my case as to what I say qualifies as problem gambling, which Betfair should have been aware of.
So sorry, but just pausing there. There are 10 diagnostic criteria, and A is persistent and recurrent maladaptive gambling behaviour as indicated by 5 or more of the following, not 3.
No, it says above 3.
So my lord, if you read the paragraph above, if you get 3 or more, you're a problem gambler. 5 or more indicates a probably pathological gambler.
Oh, I see, yes,
Yeah.
sorry.
But this quote isn't from the DSM itself, it's from something issued by the NHS, isn't it?
It is, but it's listing the diagnostic criteria.
It is, my lord, but it does appear to be, my reading of it, it's listing the diagnostic criteria without any embellishment.
I think it is accurate because I printed off from the internet DSM-4 and DSM-5, and it looks as though that is DSM-4 in its native form, and the only difference in DSM-5 is, as your learned junior has just prompted us, that number 8 is removed, but otherwise DSM-5 has therefore the 1 to 8 and 10. Is that right?
Yes,
The
yes,
next
my
page
lord.
tells you there's DSM. It's exactly DSM.
Yes. And if one turns over the page to answer Lord Justice Birss's question, so the following page, what one sees the source
Yes, I mean, you tell me, but I read this as being the criteria, that is to say 1 to 10, and maybe with the A and B, have come from the DSM. A little bit of commentary at the beginning seems to have come from the NHS, but you tell me if I've got that wrong.
It is wrong. We'll go through the
So, my lord, over the page, the source appears to be the American Psychiatric Association.
Yes.
So it seems to be a quote. Fourth edition.
I think we need to get DSM-4 and DSM-5 because there are some other differences in DSM-5, not least that these questions are asked by reference to whether persistent recurrent problematic gambling behaviour leading to clinically significant impairment or distress as indicated by individuals exhibiting 4 or more of the characteristics within a 12-month period. And then DSM-5, far from having a threshold of 3, starts at 4 and has mild 4 to 5, moderate 6 to 7, and severe 8 to 9, I think. So I think it would be helpful if we could have DSM-4 and DSM-5 in their native form. I got that from a printout from the internet. I hope I'm right, but I may not be. So we need all to be on the same page.
Yeah, absolutely, very well, my lord. I'm sure those behind me have heard that, and we'll arrange copies. So my lord, my lords, my submission on problem gambling is it's problem. These are the so we've looked at the DSM-4 and PGSI measurement instruments, but in my submission, the metric that Betfair should have been applying is that a
Sorry, but if it was DSM-5, which was the relevant clinical test in force at the time, why are we looking at DSM-4? Shouldn't we look at DSM-5?
My lord, I was only, I was only really referring to DSM-4 on the basis that that is what's been referenced in the case thus far, and it shows that there is, well, there is a definition that's been banned, that has been canvassed as to what a problem gambler is. But
So
my
which
lord,
of the 3 criteria, which of the 3 or more would you say Betfair should have diagnosed?
So my lord, spending more than his discretionary income is going to be, in my submission, point I submit, would have indicated he was a problem gambler.
Sorry. No, hang on, that's something different from DSM-4
These are a
criteria.
screening tool because you don't know someone's income. You're just asking them questions. If you actually know, they're spending a lot.
So my lord, these are simply screening tools. When one doesn't know how much somebody's spending, one doesn't know what their income is. When these are essentially ways of trying to screen whether someone may be a problem gambler. But in my submission, once one has the information that somebody is spending beyond their means, then in my submission, that is somebody you should be classing as a problem gambler.
They're clinical diagnostic tools for diagnosing a gambling disorder.
Yes.
As I understand your submission, it is that a problem gambler, for the purposes of the LCCP, involves a different concept, and that one doesn't have to satisfy the clinical diagnosis of a problem of a gambling disorder in order to be a problem gambler. Have I understood that correctly?
That you have understood correct, my lord.
So that we're not defining problem gambler by reference to these to DSM-4 or DSM-5, and you're going to go on to identify how we do define problem gambler.
Yes.
Have I understood the framework of your argument?
Yes, my lord. Yes, my lord. Yes. So if we go, my lord, the way it was seen at the way that Betfair saw healthy gambling and problem gambling was also delineated by that line of are you gambling within your discretionary income, your discretionary income. So my lord, if I could invite you to turn up bundle S6. It's tab 4. This is the cross-examination of Mr. Kleins, who was a responsible gambling analyst at Betfair.
Afraid we don't have tabs.
Yes.
So
Give us a page number.
perhaps if I give you just page numbers in that case, my lord, if one turns up page 791. And page 791 is Opus page 34. And here, my learned junior is asking questions of Mr. Kleins, who is the responsible gambling analyst from June 2015 to November 2016, and then a trainer. And he's asking about Betfair's responsible gambling presentation in 2015. And if one goes down to line 14, so could we go back to document 1 second? Miss Kleins, sorry. And he reads from the document where it says a healthy and sustainable business. Your Lordships can read it. And if one goes over the page, one just sees how those questions play out. So the Betfair presentation on responsible gambling referred to only using discretionary funds, not putting themselves in financial distress.
Sorry to keep interrupting, but what do you mean by discretionary funds?
So discretionary funds, my lord, would be the amount of available income you have to spend. Essentially, my lord, after you've paid for your bills, so income minus bills, how much money do you have left? That's your discretionary income.
So you're not a problem gambler if you spend all of that on gambling?
No. Well, my lord, one might try to mount that argument, but I submit that as long as you're spending within your discretionary income, you can afford your gambling. You're not a problem gambler.
Well, that's I think if you look at the diagnostic criteria in DSM 4, the fact that you might be able to afford what you're doing doesn't mean you're not a problem gambler.
So I suppose, my lord, the way I put it is you're
If you're
unlikely.
increasingly spending more and more money, or if you're going back over and over again to see if you can win back what you think you've lost, you'd fulfil two of the criteria immediately. And no doubt you could fulfil another one as well. And you'd do that even if you were so as rich as Croesus, you could afford all of it. So it's got nothing to do with how much disposable income you have, discretionary income you have, according to those criteria anyway.
Well, my lord, I've made my submission that those criteria are a tool to try to identify who may be at risk of problem gambling, when one is early on in the process and doesn't have the detail of how much money do you have to spend. Now your lordship's right. If one has, if one is Elon Musk and has limitless funds to spend on gambling, you may still be spending within your discretionary income, and yet you may still be you may be someone who hits the DSM-4 criteria, and you're likely to be a problem gambler.
Yeah.
But in my submission, once you are spending all of your discretionary income, in my submission, you fall within what should be seen as a problem gambler.
So I'd written down a problem gambler as one who's not gambling within their discretionary income, but would it be more accurate to describe your submission as a person who is not gambling within their discretionary income is a problem gambler? But that doesn't define the category. There may be those who have other attributes who also qualify as problem gamblers.
It would, my lord. And we have to some extent debated this a little bit already, but it is important to distinguish between a problem gambler and someone with a gambling disorder. In Calvert, Mr. Justice Briggs adverted to that distinction. One sees it in his judgment. Paragraph 118 is probably the clearest place where His Lordship adverts to that distinction, but it's elsewhere in the judgment too. And as I've submitted earlier, less factors are required to qualify as a problem gambler than someone with a gambling disorder. And for the purpose of the LCCP, it is a problem gambler that engages the protection set out. Coming back, sorry, to the LCCP after that slight detour. So your Lordships have that in front of you. So we're at paragraph 3.4, so bundle S3, tab 3, and this will be page 122, page 8 for Opus. Now, one of the things that the policies must include if one has a customer whose behaviour may indicate problem gambling is at C. The policy must include circumstances in which consideration should be given to refusing service and or barring customers from the gambling premises. And subparagraph E, the policy must also make specific provision for making use of all relevant sources of information to do various things. To ensure effective decision making, to guide effective customer interactions, and to deliver effective customer interactions. So to draw that together, the policy has to be one that takes into account all relevant information to ensure effective customer interactions when the customer's behaviour is such as to give rise to a concern that they may be a problem gambler. So, my lords, my first proposition is going to be on the proper construction and application of the codes of practice, as envisaged by the Gambling Act. A de minimis requirement of the licence conditions is that where, on the basis of all relevant sources of information, a customer appears likely to be a problem gambler, the betting exchange must ultimately refuse service to that customer. And I say that because the policy has to be a policy that delivers effective interactions based on all the relevant information. And it's a policy that must contain consideration of when service should be refused. So paragraph 3.4.1 is engaged where a betting exchange has a concern that a particular customer may be a problem gambler. Now, their policy should be ones that deliver effective customer interactions to such customers. It may very well be that having properly applied their policy turns out the customer is not likely to be a problem gambler, or there's insufficient information. Effective customer interaction in those circumstances may involve no limitation on the customer, or some limitation that falls well short of refusal of service. But if the customer appears likely to be a problem gambler, as is apparent from their cumulative behaviour, an effective interaction, my submission, must be one that ultimately refuses service to them. Because there has to be an upper end of the spectrum of responses, and that upper end has to include refusal of service to the customer by the betting exchange. And I submit that upper end is hit when you know or should know that your customer is a problem gambler.
That may give rise to a difficulty when you haven't given us a definitive definition of problem gambler, you've only identified one category of person who, say, falls within it. If you can be a problem gambler in a much wider variety of circumstances than the one you're using as an exemplar in this case, it may be rather difficult to say that in all such cases there is an obligation to exclude. Do you see the problem? If we're not dealing with a definition of problem gambler on your submissions, but simply taking an exemplar which is at one end of the scale, then you may say that in those circumstances there's an obligation to exclude. But it doesn't follow that one can interpret this as an obligation to exclude for anyone who may come in a much wider spectrum of problem gamblers.
If someone's exhibiting some behaviour chasing losses, you might restrict the amount they can do per month.
And what this requires is that the policy includes the circumstances in which consideration should be given to refusing service. It doesn't say you must refuse service. It says you've got to lay down a series of, if you like, criteria for determining when you might refuse service, but it doesn't follow from that that you must refuse service to a problem gambler. Otherwise, it will be phrased more differently. So the policy must include a provision that a problem gambler should be refused service. Full stop.
So my lord, the policy must give consideration to circumstances when one should refuse service.
Yeah.
So your lordship's right. In my submission, the logical
it gives the operator a discretion, doesn't it?
but within that discretion, there has to be a point in your policies where you will refuse service to someone. You have to consider when that is, where you place that point. You have to, in your policy, have some point in the policy where that nuclear option is triggered.
Well, Betfair did, though, didn't they? Because there was a time when they did refuse service.
Well, my lord, I'm going to submit they didn't. Their policies don't include anything about refusing service, and I will come to that in a moment when I deal with why I submit that they were in breach of the LCCP.
Okay.
So my lord, I
It might be a difficult case around the fringes where the discretion is using more than their discretionary income. You must be in that category of loan.
So my lord, to seek to address Lord Justice Popplewell's question, there may be, when one's defining problem gambling, my lord, there may be fringe cases where one can't be sure whether you have a problem gambler or not. But there will be, in my submission, well, allow me to. So my definition of, for the purpose of my case, it is that if one is spending their discretionary income, that is a clear indicator that one is a problem gambler.
I understand that, but I think you're also saying that that doesn't exhaust the entire category of problem gamblers. You could be gambling within your discretionary income and still be a problem gambler because of various other matters. If you're spending all your spare money on gambling to the detriment of your family and in a compulsive way involving a total lack of control, you might still be a problem gambler, even though you've got the disposable income to spend all of it on gambling. So I think you are saying, but tell me if I'm wrong, that the exemplar, which you say is this case, is an example of something that comes within the category, but it's not an exhaustive definition.
I'm not suggesting it's an exhaustive definition. That is correct.
Thank you.
So my lord, on my submission as to how, where one has a customer as to whom you have a concern they may be a problem gambler, how that policy how a compliant policy would operate. I mean, a compliant policy that delivers effective customer interactions may not probably almost certainly will not refuse service as part of the very first customer interaction. That might be a phone call querying behaviour. It may be sending an email, educating the customers the tools they can use to self-exclude, encouraging them to seek help. Because at that stage, one may not have enough information to ascertain whether the customer is likely to be a problem gambler or not. They may just have placed a large bet, and that seems strange, and one may ask questions about it, but one doesn't yet go to the stage of refusing service. But if those interactions do not stem or reduce the customer's behaviour, I submit an effective policy must at some point include refusal of service. And those earlier interventions form part of the relevant information that the betting exchange would have when deciding what that effective interaction is. And I submit that proposition is consistent with the Gambling Commission's intention from the outset when they set about compiling the codes of practice. The idea that there must always be a consideration given for when you refuse service. So if we could turn, my lords, to...
I'm sorry to keep slowing you down, but your exemplar of a problem gambler as one who is not gambling within their discretionary income involved discretionary income, meaning their income available to spend after expenses. Now, to what extent does the word income matter for that? Does one also take into account capital?
My lord, I would submit no, in the sense of if one has to sell assets that one has to gamble, to fund a gambling habit, that should be a red flag that is unusual, and that is something that should, in my
However rich and however much capital you may have, that would be true of Mr. Gates or Mr. Musk, would it?
If they are selling assets in order to gamble, one should, at the very least, it requires an investigation as to their ability to carry on affording their gambling and their propensity to gamble.
Even if
So
this...
if in your example somebody sold a property for them to gamble and then put the proceeds onto a horse at 100 to 1 and it came in and they made 100-fold, so they're able to buy 100 properties like the one they had previously, would that make them a problem gambler? Or they're just lucky?
Make them a problem gambler when they sold one of the 100 properties to do it again.
My lord, it would be a red flag if one sells assets in
So
order.
anything, at the moment when they sell the asset, even though they subsequently are very successful at their gambling.
Well, my lord, being successful in your gambling is usually part of the piece that many problem gamblers end up experiencing. So it is an indicator. It may not be that one refuses service at that stage, but it is these are all things, red flags that a betting exchange should be taking into account. The way in which bets are placed, spending, the losses that accumulate, assets being sold, these are, in my submission, all things that a betting exchange should take into account when it has that information.
Thank you.
So, my lords, if we go to the Gambling Commission's consultation document from March 2006, it's bundle S3, tab 1. Page 94, page 1 for Opus. If one goes forward to page 100, so this is before the codes were actually produced. Page 100, the paragraph 5.5 deals with intervention. 5.5.1 refers to intervention involving including taking action to exclude them from those facilities, the third line. So exclusion. 5.5.2, the second, about halfway through, there's a reference to Swiss operators barring those who are gambling beyond their means, and then the potential for compulsory exclusion in the Netherlands. 5.5.3, there's a reference to circumstances in which operators should intervene when they suspect an individual has a gambling problem. And this is intervene in the sense in which 5.5.1, that includes refusing service. Page 101.
Sorry, could we just read the rest of 5.5.3 while we're there?
Yeah.
So, my lords, over the following page, page 101, opus page 8, 5.5.8. And the Gambling Commission says, in that context, we suggested we would assume vulnerable persons includes people who gamble more than they want to, people who gamble beyond their means, and or some other. Further down, 5.5.11, under forms of intervention, there's a reference to operators having a role in excluding an individual where clear signs of problem gambling are displayed. And then over the page, at page 102, the third bullet at the top of the page, that's the one that refers to excluding an individual. Clear signs of problem gambling which are not mitigated by the individual taking advantage of some of the options available. And then 5.5.12 reflects the submission I made as to how the gravity of the intervention may develop as a clearer picture of the customer's gambling habits emerge. Now that intention on the part of the Gambling Commission, that as an operator you must have a policy that envisages refusing customers, refusing service to certain customers. That endured right from this early consultation paper right through to very recent papers. So the next document I'd like to take you to, if I may, is in the further supplementary bundle. I'm not sure if the Lordships have that in hard copy, but it's further supplementary bundle. Tab 12. And if you have it in hard copy, it's page 39. And this is the consultation document ahead of the changes that were made in 2015. And if one goes forward to page 41, opus page 203, paragraph 5. .1 and 5.2. If your Lordships read that. And then 5.4. So this is about an expectation that operators should not generally seek to profit from people who are harmed by their gambling or who are at potential risk of harm. And then 5.4, the Commission considered this an area where significant strengthening of the code provisions was warranted. My lords, if one goes forward to page 43, page 5 on opus, paragraph 5.14, and there's a reference there to one key theme emerging, that information available to operators for commercial purposes has not been routinely made available to help guide decisions about customer interaction. And 5.15, there's a reference to updating the code provision 3.4.1 in two ways, one of which is to require specific provision for making use of all information about customers, whatever the source, to guide customer interaction. So purpose of this document is to explain why the all relevant information part came into the 2015 code. So ensure that if you're interacting with a customer in respect of money laundering or something else, the information you acquire through that should remain within a common repository so it can be accessed by those looking at responsible gambling interactions. The next document, my lords, is bundle S3, tab 4. And this is a Gambling Commission document from February 2018. If one goes to page 134, Opus page 4, paragraph 4.3, under the heading Interact, refers to your interaction should have an outcome, and in the box underneath it, the first bullet says, we expect you to be curious, and if you spot harmful behaviour, assume that the customer is at risk until you know otherwise. Sorry, my lords, have I?
Which document is this? The trouble is when you give us a tab number, we don't know.
So it's in our part 1, tab 3, starting at page 131. It's the first page, Gambling Commission Customer Interaction Guidance for Remote Gambling Operators Guidance Note.
Yes, it is, my lord.
Well, this is actually long after the relationship between your client and Betfair came to an end, isn't it?
No, this is still during the relationship, my lord. This is February 2018. So if one goes to the end of the document, you have the date. So page 137 is the date.
Oh, it's February 18. Okay.
Yes. So this is still current.
Yeah.
And it was page 134.
Mm-hmm.
Paragraph 4.3 was what I was showing your lordships. Interaction should have an outcome, and in the red box underneath that, first bullet refers to we expect you to be curious, and if you spot harmful behaviour, assume that the customer is at risk until you know otherwise. And if one goes over the page to paragraph 4.5, that simply underscores that a customer interaction must have an outcome, and 4.12 makes clear that in some cases you may need to take action to close the customer's account. In other words, there will be circumstances which you should refuse service. If one then goes forward in the same bundle S3,
Mm-hmm.
to page 138, tab 5. This is another Gambling Commission document. This is July 2019. So this is after relationship with my client came to an end. But I'm only showing your lordships this to show that it has remained a common theme throughout, that your policies need to include refusal of service at some point to customers you believe may have be at risk of problem gambling. If one goes forward to page 142, well, first of all, page 141, paragraph 2.4. And that just refers to Wardle research defining gambling harms. It's extending beyond the individual to families, community, society, so far as you need that to be set out somewhere. Page 142. paragraph 2.8. The Commission here refers to operators not considering customer affordability when developing their interaction policies. And that's led to a number of customers spending more than they could afford. Now, that's never been acceptable, hence the reference to the Gambling Commission undertaking compliance and enforcement work. And over the page at page 143, .11, and the last sentence refers to most people would consider it harmful if they were spending a significant amount of their discretionary income on gambling. My submission is if you're spending all of it, or it looks like you might be spending even more than all of it, then that should be a clear indicator that you're a problem gambler. Page 144, paragraph 2.16. This ties into having all relevant information to make responsible gambling assessments. Having it all in one place, including records of previous customer interactions. And then over the page, page 145. Box at the bottom of the page, interact, what we expect you to do. There's various bullets. The third bullet refers to you should choose the type of interaction based on the extent of the potential harm, automated responses, human contact, and adapt your messaging to try to get the best outcome. You should trial and evaluate, going over the page, different approaches, and the Commission sets out in bold this time. This may include refusing service or ending the business relationship. And the final document onwards is also bundle S3. For those with tabs, tab 8, page 158. And this is Gambling Commission formal guidance under code 3.4.3, updated 30th of August 2023. And if one goes forward to page 160, paragraph 1 specifies licensees must implement effective interaction systems. And lower down the page, paragraph 9, those systems must include ending the customer relationship, so ending the business relationship where necessary. And if one then goes forward to page 165, opus page 8, this document sets out, so the Gambling Commission has identify, act and evaluate guidance, and this is a diagrammatic depiction of what the Gambling Commission intends. And one sees the box, the bottom of that diagram refers to cease business relationship if necessary. And onwards, if you go forward to page 179, this is requirement 9 about refusing service. And if one goes to the bottom of the page, the following content sets out information and guidance about the customer interaction suite of actions. in requirement 9, if one turns over the page. Sorry, this is Opus page 23. We see increasing severity of actions. And at the top end, very strong, refers to refusing service or completely ending the customer relationship. And then there follows, over the page, examples of types of action at increasing strength levels. And you'll see under very strong customer interactions, ending the customer relationship. So, my lords, I submit that the Gambling Commission's intent from the start of the process to date was that an operator's policy must include refusal at the upper end of the spectrum. And so my first proposition, as I submitted earlier, is it's an irreducible minimum of the LCCP. If you conclude, or someone reasonable in your position would conclude, under subparagraph E of paragraph 3.4.1, on the basis of all the evidence that you likely have a problem gambler, you should, through the application of your policies, refuse service. And I adopt the Gambling Commission's words from the document I showed you. Your interaction should have an outcome. Because otherwise, I'd ask the question rhetorically, what's the point of noting in your records that Mr. X or Mrs. X is a problem gambler and doing nothing, allowing them to self-combust?
Well, the document you've just shown us, which admittedly is after the events with which we're concerned, suggests that there are a number of responses which are tailored to the number and level of indicators of harm. One works up a scale, and the final one is exclusion. But why would it not, for example, be sufficient if you did have concerns about affordability to place a limit on spend as opposed to exclude? Why do you say the obligation is always to exclude?
Well, that might be one of your one of the interactions along the way, and if by placing a limit on the problem gambler, one or the person you suspected was likely to be a problem gambler, that controlled the problem. They didn't push back. They didn't ask you about increasing the limit, and everything seemed fine. That might be an effective interaction. These things are, in my submission, they are fact dependent to a large extent as to what is an effective interaction.
So do you maintain your submission that it's a de minimis requirement, that if the exchange knows that someone is likely to be a problem gambler, they must exclude?
Well, my lord, I suspect I could relax it to they must exclude or place a limit that ensures the gambler is gambling within their discretionary income.
Within their discretionary income?
Yes, my lord.
Thank you.
If they're prepared to tell you about that, if they won't tell you about their income, then you have to refuse that.
My lord, my junior points out, to some extent, knowing what their discretionary income can sometimes be tricky, because often the gambler will not tell you what their discretionary income is.
Well, how do you find out?
Well, in those circumstances, my lord, if you don't know, then you should refuse. If you believe you have someone who's likely to be a problem gambler, who refuses to give you information, declines to give you information about affordability, what their income is, what they spend, and it seems to you on all the information this is a likely to be a problem gambler, if you cannot set what you might regard as effective limits, then the only effective interaction in those circumstances would be to refuse.
I don't want to take a lot of time over this, but another effective limit that's referred to here is time, money. Time out. Why isn't the same qualification that you just accepted from my lord? I'm not trying to play a game with you, it's not. But I don't understand why the logic of that doesn't apply to a time limit as well.
It's a different arm, so people are gambling, antisocial hours, ignoring their family, and that might be a problem in itself, regardless of how much they're spending.
It's time or money, isn't it?
So, my lord, a timeout, a suspension, may very much be one of the interactions on the road to what I submit as the ultimate interaction. And what one would do is, yes, you can put a suspension on someone's account, and Betfair did put suspensions on people's accounts. And then what would happen is the customer would call up and say, please lift my suspension. And we will look at that in a moment. But to answer Lord Justice Birss's question, if for example one has a time interaction, which is effectively you can't gamble for 3 months, if after the customer comes back and they are still gambling in a way that you regard as displaying behaviour that gives rise to concern they may be a problem gambler, well then that interaction in my submission has been ineffective. One has to then work out, well, what does one do next? My lords, I'm not sure if we're taking breaks for the transcribers. If we are, that might be a convenient moment.
Well, I think we tend not to,
Well,
unless there's a specific request or somebody's expiring or there's only one person from Opus here. But so I think we'll carry on. I mean, this appeal is down for a day and a half, and it has to finish by 1 o'clock tomorrow without fail. Right. So if we can't sit beyond 4:15 this afternoon, if you need to sit earlier tomorrow, we will consider it, but we're not encouraging it.
very well, I understand. As to why I submit that the LCCP sets out a minimum requirement, that was confirmed in the commission document referred to in the judgment in paragraph 35 of the judgment. The judge there refers to a 2017 document that refers to paragraph 3.4 of the LCCP, setting out the minimum standards that licensed bodies are expected to comply with.
Sorry. Paragraph 35.
35, yes, my lord.
Sorry, is that one of the documents which just shown us? June 2017 document?
No, my lord, we don't seem to have that in the bundle. We don't seem to have that in the bundle.
Sorry, I don't know what document you're talking
No, we don't have that in the bundle.
Okay.
My lord, I'll deal briefly with Betfair's response to my construction of the LCCP. Now, Betfair says that the LCCP was not prescriptive or demanding, and in saying that they lift from the judge who said the same, and his lordship said that the LCCP was not prescriptive about triggers. For your note, he says that at paragraphs 27, 29, 33 and 133. Now, I submit that that's the wrong way to look at it. The LCCP didn't get into granularity. Gambling Commission didn't get into granularity. That was left to gambling operators. But what compliant policies were required to achieve was and always has remained the same, and it's been clear. So just to make good that point, if one goes to S3, page 104, and goes forward to page 109.
What's this?
This document, my lords, is The document we looked at earlier, the Gambling Commission's document from February 2015, the amendment document.
Yeah.
And at page 109, which is Opus page 6. No, it's tab Opus. It's tab 2, page 6. And paragraph 1.2 of the document. And it's the second sentence which refers to so it's reference to operators being much better placed to understand the practical trade-offs between minimising harm, innovation and customer experience. Paragraph 1.3 refers to trying to minimise prescription by stating what outcome is expected and leaving it to the operator to decide how best to achieve that outcome.
Right.
And that's also clear from the original consultation document, which is S3 tab 1, page 94. And if one goes to page 99, so if it's Opus, that's S3 tab 1, page 6. Paragraph 2.1.6, Gambling Commission says something similar. Generally, will set out what needs to be achieved and leave it to operators to decide on the most appropriate means.
Right.
So as time went on, it became apparent that gambling operators weren't adopting good practices that try to achieve the intention of minimising harm. That's why over time more express requirements were spelled out. But that didn't detract from the fact the very same outcome was always intended. And so while we're in this, so if we go to S3 page 112,
Page.
sorry, S3 tab 2, page 112.
Yeah.
Paragraph 5.1. And that is the Gambling Commission referring to the fact that it anticipated that good practice would develop over time, but it's been slow to develop. But the intention throughout was, in my submission, the same. It was clear. It's that betting exchanges needed to have a policy. They had to implement it. And from the 8th of May 2015, it had to be a policy that would deliver effective customer interactions based on all the relevant data. I come now to the judge's findings and my submission that he is wrong to the requisite degree. Now, on that requisite degree, the test for overturning findings of fact, of course I can agree that it is a high hurdle. In Haringey, London Borough Council and Armid, that's been quoted by both parties, an irrationality threshold was suggested. A decision that no reasonable judge could arrive at. That is sometimes the test used, but I query if that doesn't perhaps put it a little high. More recently in Global and Grey, which my own friends quote, if I could turn that up, it's bundle A2, second part, tab 33. And if one goes to page page 1084. and it's paragraph 289. It's opus page 7. And the Court of Appeal quotes from the Supreme Court decision in Henderson Foxworth Investments as to the test. It's the making of a critical finding of fact which has no basis in the evidence, or a demonstrable misunderstanding of relevant evidence, or a demonstrable failure to consider relevant evidence. The court will only intervene if it's satisfied the decision cannot reasonably be explained or justified. And we've also referred in our skeleton to Supreme Court decision in Re B. That probably sets out the formulation in the lightest terms. It's in Re B, case about whether the child in question was likely to suffer significant harm. And in the case, I'm not going to take your lordships to it. Actually, probably is best I do. Sorry. If your lordships turn it up, it's also bundle A2.
Yeah.
Tab 23. Page 695. Sorry, page 714 of the. So if one starts at page 696. Head note. Paragraph 2 of the head note refers to the appellate court only intervening when satisfied the judge's findings of primary fact were wrong. And that's spelled out in greater detail at page 714 of the bundle. It's paragraph 44. Lord Wilson sets out his version of the test. The highlighter section refers to Lady Justice Hallett.
This is a debate about whether it's wrong or plainly wrong or clearly wrong or demonstrably wrong or whatever. And he's simply making the point, if it's wrong, and you shouldn't add an adverb to it, which I remember being referred to previously.
Yes. So my lords, I accept that one needs the court, an appellate court needs a clear sense of why it said the trial judge arrived at the wrong finding of fact, given the advantages the trial judge will have over an appellate court in terms of assessing evidence. And that will usually require a failure to take into account or understand evidence, incoherence, or some kind of irrationality, something not adding up in terms of the evidence and the conclusion.
This is all pretty familiar territory, but for what it's worth, there is a very recent decision of the Privy Council in a case called Trina and Masso, in which the judgment was either last week or the week before, in which I happened to give the judgment to the board, which covers these principles. Again, same territory. I'm not suggesting that it breaks any new ground, but the party should be aware of that in case they want to say anything about it.
Thank you, my lord. So my lord, this leads to my second proposition, that the judge's finding that Betfair was not in breach of the LCCP was wrong to the requisite degree. So that's incoherent, irrational, plainly wrong. It crosses the threshold. So there's no dispute that Mr. Gibson was a problem gambler. The judge found he was, paragraph 126 of the judgment. The experts agreed that he also had a more serious condition of a gambling disorder, and that's recorded in the judgment at paragraph 124. Now, The judge found Betfair was not in breach of the LCCP, and the basis for that is at paragraph 129 of the judgment. And the basis was that Betfair was not aware and cannot be taken to have known of Mr. Gibson's gambling problem because he kept his problem to himself and was not being honest with Betfair. And as a result, they could not know that he had a gambling problem. And he described this as insuperable difficulty to Mr. Gibson's claim. And if one goes forward in the judgment, paragraph 132, it was on that basis that he held that Betfair was not in breach of the LCCP. My first submission on this point, my lords, is that the judge appears to have fell into some kind of muddle here. So the LCCP, paragraph 3.4.1, requires Betfair to put into effect policies where it has concerns that a customer's behaviour may indicate problem gambling. So to be clear, the level of knowledge required by Betfair to trigger the putting into effect of its policies is not knowledge that the customer is a problem gambler, rather they should have concerns that they may be a problem gambler. I'm prepared to assume that the judge's formulation is an alternative shorthand for what I submit is the correct target. But if it is, his finding that Betfair was not aware and should not reasonably have been aware of Mr. Gibson's problem gambling is incoherent. And I say that because the judge refers in the judgment to Betfair undertaking various customer interventions. So sending AML and responsible gambling emails, making responsible gambling calls, conducting enhanced due diligence reviews, and suspending Mr. Gibson's account. And to give your lordships some references, that's paragraph 93 to 94 of the judgment. That's one of the places he refers to these interactions taking place. And also at paragraph 101 of the judgment, among other places, there's another reference to responsible gambling intervention, not simply an email. Now, RGI interactions, so RGIs, the responsible gambling calls, and these various interactions, they only happen when Betfair has taken the view the customer's at risk of problem gambling. And some of these are quite serious interventions, querying the specifics of whether you can afford to do what he's doing.
Well, is that right? I'm not sure about that. I mean, 93, where they're quoting the internal documents, the judge is quoting the internal documents. The question that's being asked there, in effect, what's being done is that they are conducting these reviews with a view to satisfying themselves and ensuring that he's still gambling within his means. So they're not intervening because they suspect he's not gambling within his means. They're intervening to ensure that he is still gambling within his means, which is a different thing.
My lord, the point is...
And the point the judge made in the paragraphs you showed us a moment ago is that Mr. Gibson dissembled about what his means were and what his gambling was.
My submission, my lord, is that it's very much like that sort of ladder of severity we saw in terms of responses. One doesn't actually get to these later responses of making calls to the client, RGIs. One doesn't even get to that stage. If the true position is you have and can have no concern that this customer is at risk of problem gambling, that call just won't happen. I mean, one might at very most get some automated response talking about tools that are available, but these are quite specific interventions with Mr. Gibson. And I submit that
The suspension, for example, was because they weren't satisfied with the documentary evidence that he'd sent them as to his means. It wasn't because they concluded he was spending beyond his means, because they weren't satisfied with the evidence he'd produced that he wasn't spending beyond his means. And what then happened is he produced more evidence, which led them to incorrectly, because he hadn't told them given them the full picture, led them to restore his account.
so
Isn't that what happened?
So my lord, many of these were, you're right, AML interventions, seeing if he could. Well, AML is directed not just affordability. Affordability, in my submission, is responsible gambling. AML is looking at, is this a legitimate source of money you're using? Show me where you're getting your money so I can be convinced that this doesn't derive from some improper route. So there were AML interventions, and as the judge said in his judgment, he didn't separate AML and RG, responsible gambling requests. He thought the two went very much hand in hand. Lordship, I think, says that.
I mean, I understand there is a distinction, but is it a distinction that matters in the light of the way you're putting your case, which is it's all about affordability?
Well,
Sorry, not all about affordability, but you put affordability at the heart of the case.
I do, and so one of the reasons I'm going to be submitting that Betfair's policies were inadequate, and plainly so, is that there wasn't a joining up of the information between what the money laundering people were getting and the decisions the responsible gambling people were taking. And so, to some extent, my lord, I submit that when you're making, there were messages where in the judgment there's reference to responsible gambling interactions, and so my point is, on the basis of the judge's own formulation of these exchanges as being responsible gambling interactions, related not just to the legality of the money that's being used, but the affordability, which relates to, can you safely gamble, the responsible gambling part of it. In my submission, it doesn't make sense to refer to these exchanges in the context of them being responsible gambling interactions, and then say that Betfair has and could not have had a concern that Mr. Gibson may be a problem gambler. So I submit that is an incoherent finding.
Doesn't that come back to the point that you made before about what question the judge was asking himself? The judge wasn't asking were they concerned. The judge was asking, did they know or ought to have known that he had a gambling problem? And then you said, well, actually the real test should have been, were they concerned, when you're going to take that as a shorthand. But that's exactly not what the judge was doing. Isn't the answer to this that the judge is looking at the facts and saying, well, they obviously did have questions which they asked, and the ultimate issue isn't did they have questions, the answer is did they know he had a gambling problem, to which the answer was no.
Part of which,
Having
was-
asked the
part of
questions.
which they kept on asking the questions, and he kept on getting the answer that he was perfectly happy with where he was.
Well, my lords, I
Now,
submit.
the truth is that might not be enough in itself, but they also had the evidence that he'd given them as to what his income was, a lot of which, or from which the judge found they were entitled to conclude that he wasn't spending beyond his means.
Well, my lord,
So it's not, as my lord said, it's not a question of whether they had concerns, because they plainly did have concerns, but their concerns were raised with him, and any fears they had were allayed.
well, so my lord, to some extent, I submit the knowledge part of the judgment. One wonders where it features when you're looking at breach. So when you're looking at breach of the LCCP, which is the question where I submit that the judge heard, the test is, well, one has to apply the LCCP test, and so is the customer's behaviour such as to give you a concern they may be a problem gambler. So that is the correct test to apply. If the judge has applied a different test, well, he's applied a different test that's not the correct test. What I'm submitting is if he were to apply the correct test, so essentially the judge's knowledge finding seems to be paragraph 3.4.1 isn't even really triggered because we don't get over the knowledge threshold that would have triggered.
I'm sorry, I just don't understand that. The LCCP test of saying, is there something that would give you a concern, doesn't say, and if there's something that gives you a concern, that means you can ask questions, you will refuse them business. The point about the concern is that you start asking questions and you start your process. Well, they did start a process. Your case is that the end point should have been in their policy, that they would have got to a point where they would have stopped him. But surely the end point of stopping would be if you knew that they did have a gambling problem, having had concerns. So I don't know, you seem to be shifting around.
And the problem you've got is that on the question of knowledge, which is what we're on, and there's a detailed section of the judge's judgment, where he gets to at paragraph 109 to 111 is in the summary of the interactions, in which he concludes that, in effect, that Betfair didn't know that he had a gambling problem and weren't in a situation where they ought to have known he had a gambling problem, not least because he deliberately misled them.
Well, my lord, allow me then to
You've got to get over that hurdle.
allow me to address that point head on then. And so we say the judge was wrong to the requisite degree to arrive at that conclusion, and we say that is because it is out of kilter with his own findings of fact that I shall take you to, matters that were common ground, and evidence of Betfair's own witnesses whom he found reliable. And there are 6 points I will be making under this head as to why I submit that the judge heard. So the first, my lords, is that on the figures that Betfair had for Mr. Gibson's income and losses, Betfair would have known that his disposable income would not be enough to sustain the level of losses he was suffering. And in those circumstances, in my submission, that would have been an indicator that he was a problem gambler.
At all stages from 2015 or at a particular point in time?
Well, my lord, we submit at all stages from 2015, but I understand, perhaps if I show your lordship, but our cases from all stages from 2015.
Would you want to tell us what the 6 points are first, and
Very well.
then flesh them out, as it were?
So first is that on the figures they had, they would have known his disposable income would be enough to sustain his losses. Second is that Betfair knew that Mr. Gibson had suffered heavy losses, which were getting worse, in circumstances where it had always treated heavy losses as a fairly obvious indicator of problem gambling. The third is the sheer volume of bets placed by Mr. Gibson would suggest he was at risk of problem gambling. The fourth is that Mr. Gibson was clearly frustrated when his access to the Betfair exchange was temporarily suspended for AML checks. The fifth is that Betfair knew he was gambling using funds released from selling assets or encumbering assets to obtain loans. And the sixth is that the evidence of the experts and Betfair's witnesses was that this was not or should not have been a difficult case to spot.
Okay.
And so I'll take each of those in turn. But on the first, that Betfair would have known his disposable income was insufficient to sustain his losses. If one goes to the judgment, my lords, paragraph 77, the level of his losses is summarised in paragraph 77 of the judgment. And what one can see is that by December 2016, his losses are £700,000. He then loses his next 100,000 over the following 9 months to September 2017. And then before that, between December 2015 and December 2016, he's lost £200,000. So that's set out of the judgment. If one then goes forward in the judgment, paragraph 82, 82 to 83. So from October to December 2016, Mr. Gibson's asked for details of his income. He failed to supply documents, so his account is suspended on the 1st of December 2016. And then he sends an October 2016 Halifax statement that shows a difference between credits and outgoings which comes to 23,937. So the difference between the 72,677 and 48,730. And then it says which after clearing overdrawn balance leaves 15,993. But if one takes 23,937 a month, that's what Mr. Gibson is telling Betfair.
Where's that?
So my lord, that's my arithmetic. So within paragraph 83, there's a reference to deposits of 72,677.97 and outgoings of 48,730.
That was 1 month.
That was 1 month.
Don't we need to go on to paragraph 34, because
Yes.
the upshot of the 2016 inquiry is at the end of 84, he forwards a full copy of his September 2016 bank statement, and it had a number of entries ticked, and that was intended to give the impression that those were all income, and that shows, we see from 85, 64,000 for the month as an income in September. Leave aside the next bit, and then if we go to the end of 86, he's estimating his monthly expenses, including mortgage payments, as about 10,000. So what Betfair are being told at that stage is that so far as the income from the rents is concerned, then the net income is something of the order of £54,000 per month. Am I right so far?
My lord, yes.
And that compares, if I've understood the figures at paragraph 77, with losses over the 4.5 months to November of 100,000, which is about 22,000 a month. So what appears from that is that he's got disposable net income just from the rents, of 54,000 a month, which has serviced losses of 22,000 a month. And that doesn't show unaffordability, does it?
Yeah, well, my lord, I suppose the income to some extent is income pre-tax. So one might have to factor in the fact that that 64,000 figure would reduce, but
For its own bills as well.
and there'd also be expenses, the bills of the properties. But my lord, so you
No, I've taken that out because at the end of 86, he's said his monthly expenses, including mortgage payments, were about 10,000.
Business expense.
and then in 86 as well, it says that and 86, the knowledge in 86 probably can't be affixed to Betfair originally, but it can later when they obtain his tenancy statements. That suggests his monthly income is 30,882. Because the judge refers to the picture painted by the bank statements wasn't wholly accurate. And on the true basis, the actual amount of monthly income before expenses was 30,882.
When does the judge find that they found out the true position?
My lord, I don't believe he does
For
refer
that month?
I don't believe he does refer to
It's 95.
No.
It's later. It's later.
My lord, I'm
I
told
understand your case is from all the period from 2015 onwards, and it may be that you're on stronger ground when we get to 2017 or 2018. But speaking for myself, these figures don't strike me as something which showed to Betfair a lack of affordability, even if it's right only to look at net income from the rents after expenses, which may not be the right question, because there was also 94,000 for the month coming in from receipts from property sales and remortgaging.
My lord, to answer the question about does the judge record anywhere in the judgment when Betfair became aware of the actual the paragraph 86 figure, my learned juniors pointed out paragraph 95, which I think is supposed to be the point at which it's the 27th of June 2018, where Mr. Gibson provides details of his properties.
That was dealing with a different period of time.
I'm sorry, it does look.
Yeah, this is it, this is
That's
2018.
That's not the 2016 rentals.
No, I was asking when they became aware, if at all, that the September 2016, which was what you just referred us to, this September 2016 income, net income figures were incorrect.
My lord, they would have become aware at some point, but I'm afraid I can't assist.
Well, they may not have become aware until the balloon went up, if they put it that way. This is why I was asking the question. Right. Okay.
So my lord, if we then go to where I was before, if that's right, it's a different point. Judgment, paragraph 94.
Mm-hmm.
So you've skipped over 2017, but again, it doesn't seem to me that if we look at the losses over the course of 2017, which go from 700,000 to 800,000 between November 16 and September, and then another 100,000 by the end of October. And if we try and compare that with what's going on at paragraphs 90 and 91, we're still talking about monthly losses which are well within the income which had previously been disclosed in 2016, aren't they? In terms of monthly losses.
I mean, they only asked for 1 month, which is it doesn't.
£100,000 in 9 months, or £200,000 in a year. Let's put it that way.
I mean,
That's way below 54,000.
allow me in that case to move forward in time.
Right. So 2018.
To 2018.
You may be on more promising ground.
Right, okay, 2018.
So it's paragraph 94. This is June.
94, yeah.
And this is June 2018, where Betfair asks for more information as to how Mr. Gibson is funding his account. By this point, his losses are over £1 million. And at paragraph 95, the judge refers to Mr. Gibson sending a spreadsheet which sets out a monthly profit of £22,552.98. Now that gives an annual profit of about £270,000 before tax. If one factors in tax, that drops from a 45% rate, it drops to closer to £148,000 a year. But in the year from June 2017 to June 2018, he's lost more than £200,000.
So you gave me a figure of 22,552. I don't see that. Very simplistically, just look at the number you read out.
I'm trying to work out where I got. So, my lord, it says monthly rents are recorded at 3177.69 with the mortgage costs of 762.71.
Oh, I see.
I did the arithmetic, and
Okay,
the judge just says it's in excess of £22,000.
You gave us the annualised figure.
Yes. So the annualised figures before tax, £270,635.76, and after tax, I suppose that's closer to about £148,000 a year.
That one is before all the bills on all of this property.
But in the year, my submission is, in the year prior to that, June 2017 to June 2018, he's lost more than £200,000. So I submit this should suggest there's some sort of problem here. And going further on in paragraph 95 to page 122, there's reference to a message of the 29th of June, which suggests that Betfair's alive to this affordability problem, where it's an internal message, and your lordships can read it.
Where that gets to is he then sends further information, including what's said at 98, with the false suggestion that he'd taken legal advice and his lawyer was struggling to see why they thought the affordability test wasn't satisfied. And then we got Mr. Brown's internal email the 6th of July, sets out the position in detail and concludes that he wants to see some more evidence, which they then get, 99, and they reopen the account.
So my lord, the paragraph 98, which I'm going to deal with under another head, is I submit that shouldn't resolve concerns about affordability, because if a customer about whom you've got concerns whether they can afford their gambling says, I've sold 3 houses and that is now allowing me to gamble, that in my submission should raise alarm bells, that isn't normal behaviour, and so my lord, one take.
Because what he's saying is that he sold 3 houses. I mean, what he's saying at 98 in the WhatsApp is, I forgot to tell you that the best part of 18 months or longer ago, I sold 3 houses, and so I made 140,000. He's not saying I sold 3 houses in order for me to gamble at all. He's just saying I sold 3 houses, which he does seem to have done. I mean, he does seem to have been selling houses as well as buying them and remortgaging, irrespective of his gambling. It wasn't directly associated with it.
Well, my lord, I suppose if your gambling doesn't fall within what I described as your discretionary income, your usual income minus expenses, and the only way you can sustain it is through the sale of assets. Even if one might say that at the point they were sold, they were not expressly sold for the purposes of being used in gambling. That should, in my submission, that is a relevant information for assessing whether someone has is a
But
problem.
doesn't that depend on the value of the assets? If during this period, as I think was the case, the property market was still rising and the net value of the assets was increasing, suppose he has 12 properties and he thinks, I need to make sure that I can draw on the capital value if it's increasing, but I'm going to keep it the same, and so I can afford to realise 100, 200,000 a year out of selling or remortgaging the properties without actually diminishing my net assets at all. Why shouldn't one take account of that 100 or 200,000 for affordability purposes?
Yeah.
Why does it have to be limited to income from the rents? It's all part of whether something is affordable or not. Depends on people's net wealth position, both in terms of income and assets, doesn't it?
My lord, in principle, yes, I have to agree with that. But I'll deal with the selling of assets in a moment. But I submit that when Betfair has information, 2018 at least onwards, that suggests that his gambling losses cannot be accommodated, or don't seem to be able to be accommodated within the figures he's providing them with. That is indicative, or should have been indicative, that this is an individual with a gambling problem.
That's what I'm difficulty following. That assumes that he couldn't afford to sell those properties or remortgage those properties and maintain his net wealth at a level that he thought was very comfortable.
Which is effectively what they're saying in that what Mr. Brown is saying in that email of 6th of July 2018, because he says, the passage on page 123, about 6 or 7 lines down, the rental income provides the individual with a sustainable income to offset the average yearly loss on the account of 133.6 thousand. We also have additional comfort from the information on this individual's company on due diligence. He then sets up the net assets, the fixed assets, the shareholder funds, and concludes that the net wealth is more than enough to make the losses that are being suffered affordable. And then he goes on to deal with the property sales, which were in September 16, and the remortgage in September 17. And another house sale in January 18.
My lord, allow me just carry on with a couple of submissions as to why
I'm
I
sorry, we're interrupting you too much.
not.
Sorry.
With why I say it should still have been apparent. I mean, in spite of him saying he's selling assets, and I'm going to come to these messages in a moment under a different head. In the judgment, going on to paragraph 105.
Yeah.
His Lordship found that between the 25th of November 2018 and the 17th of January 2019, Mr Gibson lost £134,693, during which Betfair received 8 alerts in respect of his activity. Now, my lord, a loss of 134,693 over 2 months was, I submit, not affordable on the income he was presenting to Betfair. And I would add that if Mr Gibson's activity triggered 8 problem gambling alerts, it is strange to suggest that Betfair could not have known that he was a problem gambler, or could not at least have been put on a trade of inquiry to establish whether he was or wasn't. 8 alerts also suggest that there's no effective policy to escalate interventions. Now, those were the points.
In fact, they asked for further information, further financial information, weren't satisfied with it and suspended his account. Didn't get any more from him and then closed his account. So this is all at the end, isn't it? This is all right at the end.
This is for AML purposes, then.
Right.
Well, if I show you those were excerpts from the judgment. If I could show you a document, which is S2, page 85.
Mm-hmm.
The Opus S2 tab 8, page 1. This is a email on the 4th of July 2018 from someone called Matthew Brown, who is an AML analyst at Betfair. And it was during what's been called the 3rd AML review. And at the bottom page, he refers to strongest concerns, these are AML concerns, relate to losses in 2017, 342,000. And the second bullet refers to him having an income of 240,000 after mortgage payments, but that would be before tax and any property expenses. Now, I submit that, again, that suggests that he's unable to afford his gambling. And the evidence of Betfair's witnesses was that they knew that Mr Gibson's home was valued at £214,000, considerably less than his gambling losses during that time, and much less than the 1.26 million he lost by that point. It was less than his gambling losses in the previous year, and much less than he lost cumulatively. And that was in the evidence of Mr Burke, who was an AML senior analyst. And I'll just give your lordships the reference for that. It's S6 tab 11, page 1170 and 1173. And the evidence of Mr. Rourke, who was his VIP manager, was that he knew that the amount of money gambled and gambling more than you could afford to lose were important indicators of problem gambling. And that is, so that's S6, tab 3, page 690.
So what was the first half of that? The second half was that gambling more than you could afford to lose was an indicator of problem gambling. Nothing very surprising about him accepting that as a proposition. What was the first half of
The amount of money gambled.
in this case? At what stage?
As a general, so perhaps if I show you, so
It's just a general proposition that you can sometimes tell from the amount being gambled.
the sheer amount gambled.
Can be an
This is
indicator
your
of
third point
problem
about
gambling.
the sheer volume of bets, is it?
It's not. It's still part of my first, but my lord, it'll be relevant to my third as well.
But it's an acceptance of a general proposition that the sheer amount of gambling
Yes.
can itself be an indicator of problem gambling.
Yes.
I see, thank you.
So, provide your lordship that reference. My second point then is that Betfair knew that Mr. Gibson had suffered heavy losses, which were getting worse, in circumstances where it had always treated heavy losses as a fairly obvious indicator of problem gambling.
Yeah.
So in the judgment, paragraph 1 records his losses of 1.48 million across the 10 years that he gambled with Betfair.
Yeah.
And then judgment, paragraph 77 sets out the various losses that we looked at.
We looked at
And then-
77, yeah.
And the judgment at paragraph 135, which is
125.
135, my lord. There, his lordship says, gambling industry experts agree that Betfair's policies changed and became more sophisticated in 2015. Before then, they'd identified problem gamblers by reference to fairly obvious indicators like self-identification and heavy losses. So from that, I derive the proposition that heavy losses are a fairly obvious indicator of problem gambling.
Yeah.
And also viewed against the evidence of Betfair's forensic psychiatric expert, Dr. Fraser, whose evidence was accepted, was that if somebody carries on gambling in the face of losing large amounts of money, that's a differentiator between somebody with a gambling problem and someone who's simply betting. That's his evidence on day 7, and the reference is in our skeleton, paragraph 15.
Yeah.
My third point is the sheer volume of bets placed by Mr. Gibson. It suggests he was at risk of problem gambling. Now, though the precise number was not agreed between the parties, Mr. Gibson alleged he had placed more than 30,000 bets. The Betfair, in response in their defence, said it was less than 20,000 bets. Now, whichever of those figures is correct, I suppose what's clear is we're talking about a lot of bets.
Over 4 years or something like that.
Still, I submit that is still a lot of bets over
But
4
it's
Well,
But over
I-
the 10 years,
I
the
think
10
it's
years,
over
or the
10
4
years.
years.
It's an average about 5.
sorry, Mr. Davis-Jones.
Forgive me, I think those figures were the 10-year period.
It's
Over
average
10
about
years.
5 a day, right?
Correct.
Speaking for myself, that sounds like a lot, but I'm not a gambler, so I really don't know. How do I assess whether that is a lot? Is that a matter of evidence?
My lord, it's I can't point you to sort of any independent research about the volume of betting. The one thing I would show your lordship though is if one goes, this is a confidential
They
bundle.
were all on,
document.
they were all on football matches, were they?
They were on, yes, they were.
All of them.
Almost all of them, like more than 95%.
I'm not sure if your lordship heard that. Almost all of them, more than 95%.
Right, okay.
correct score market in football matches.
That doesn't mean that number of different football matches. I mean, one can have quite a number of different bets on an exchange on the same match in play, betting and laying as you go along.
My lord, just in terms of trying to give your lordship something quote independent by which you can assess this, I was going to take you to some research commissioned by Paddy Power, previously the sister company, now part of the same company. That is in S8, which is a confidential bundle, which means this part doesn't come on the transcript.
Is that not on? That's not on.
So my lord, this is a.
Is it on Opus or not?
That is, I think,
Yes.
it is on Opus, my lord. Yes.
Okay.
So
S8
S8,
page.
page 1535, but it's page 1555, 1555.
This is the McGill University.
Yes, my lord. And it's and there they simply state that bets over €1,000 are indicative of problem gambling.
So where's that?
Trying to read my
Which page?
That's page 1555.
1555. Thank you.
Sorry, where are we looking on that page?
It's the second paragraph on the conclusions on the left.
Productive
sorry, my lord.
models identify the number of easily obtainable key metrics,
Yes.
differentiating problem and non-problem gamblers.
Sorry, my lord. It's
Having staked over €1,000. Well, and doesn't that? I mean, that's talking about problem and non-problem gamblers who put down that stake, isn't it? Isn't it making? I mean, that suggests that the amount of the bet or the number of bets isn't necessarily an indication of a problem gambler.
Well, my lord, I read it. It's the model identifying a number of metrics to differentiate between problem and non-problem gamblers, and having staked over €1,000 being one of those metrics. So if you have, then you fall on one side, or at least that is an indicator that points
Over
to
€1,000 on one bet, is that the?
that's how I read it, my lord.
Yeah, okay, all right.
At least, unless my maths has failed me, if you've lost about £1 million on 20,000 bets, betting £1,000 very often.
Yeah, he was making bets of 10,000, 25,000.
So my lord, there were bets of 10,000, 20,
I
25.
don't doubt that, but I thought the total losses were £1 million or so, 1.4.
I think 1.48 over 10 years.
Divide that by 20,000, which
This is not
is
about
the number of bets
average.
you said.
It's not about average
The
bets.
average is much lower than £1,000.
But my lord, that would fail to take into account the bets you place that are more than 1,000, where you win. So there'll be some of those bets over time where you make some money on the bet. So my lord, I submit that just the averaging out of
Okay.
1.4.
How do I work out whether this one is satisfied then, this criterion, based on the information you've given us?
I mean, if you just think about it as a matter of common sense, I mean, my lord's much better at the maths than I am, but 20,000 into 1.4 million is 70.
Right.
So even if he was making huge amounts of money on bets that he won, you don't get from 70 to over 1,000.
Well,
I mean, that suggests that the average bet, even taking account of winnings, was probably in the region of £150, or possibly even less.
I mean, the difficulty is that we are island hopping here. We don't have the underlying material. I'm sure you're right to say that there were some bets that were much larger sums, but
Yes,
how many and how often and whatever,
Yeah.
it's just outside the scope of what can legitimately be reviewed, isn't it? on an appeal on facts of this nature.
I recognise that, my lord. My lord, I'm conscious of time. I will try to power through to try to get through
Yeah, sure.
as many of my 6 before lunch as I can.
Yes, sir.
So the fourth ground, which I realised, is that Mr. Gibson was, the judge records, Mr. Gibson was clearly frustrated when his access to the Betfair exchange was temporarily suspended. And he records that at paragraph 87 of the judgment.
Well, there's several paragraphs.
Several paragraphs where he says that.
I think one can pick up that point.
And the instances of frustration found in the judgment are cases where that frustration is expressed to Betfair. They are messages that he's written, paragraphs 87, 97, 107.
Yeah.
And I submit that finding has to be seen against the evidence of Betfair's forensic psychiatrist, which was accepted to the effect that if Mr. Gibson frequently became irritable when access to the exchange was prevented, that would be an important indicator of problem gambling.
I have some difficulty with that. I mean, it's true that DSM-4 identifies as one of the it's restless or irritable when attempting to cut down or stop gambling. But if all that is happening is that he's getting frustrated that he's having to provide a lot of documentation because they don't seem to be taking him at his word, I have some difficulty myself in understanding how that is indicative of problem gambling. I myself get quite frustrated sometimes when anti-money laundering requests seem to require the most ridiculous level of detail for what is an inquiry that doesn't seem to justify it.
So Mondo, I would submit it's in the context of somebody who's gambled heavily, lost lots of money, and they are getting frustrated at the idea that they're being kept out of being able to carry on gambling.
And is that what he was being frustrated? He was frustrated at the idea that he had to keep providing the information. That doesn't mean he was irritable, but because he couldn't gamble as such.
He's 87, what he's saying is, I sent you a whole load of information about my bank statements. Have you actually bothered to look at them or not? Because if you haven't, I'm going to go elsewhere. I mean, that's what he's saying, which is not the same thing as being frustrated because he's, I mean, it's really the same sort of frustration as my law's talking about. You ask for a whole load of additional information and then you sit on it. And we all know, don't we, that, you know, in that kind of situation, you can get irritated. But I mean, I follow the point that he certainly got extremely irritated when he was asked for things.
But my second point is that the clinical indicator is becoming restless or irritable when attempting to cut down or stop. And that wasn't the circumstance at all.
My lord, I see the distinction. I see the distinction you draw. My submission is, of course, predicated on the frustration being aimed at being deprived of being able to carry on gambling. And if the frustration is, in your assessment, aimed at consternation at being hauled over the coals for more documents,
I think all I'm saying is one can understand such frustration in someone who is conducting affordable gambling, just as much as in someone who is a problem gambler.
Yep. So my fifth point is that Betfair knew that he was gambling using funds released from selling assets or encumbering assets to obtain loans, and we've to some extent traversed this territory already.
Yeah, we've seen the references to that in the paragraphs you showed us.
Now, what I haven't shown your lordships is that Betfair's witnesses did give evidence to the effect that they would regard this as being the kind of thing that would be indicative of problem gambling. So Mr. Rourke, his VIP manager, if I take you to his evidence first,
Yeah.
that's S6, tab 3, page 690. And really, I can fast forward, my lords, to page 691, which is the nub of what I wanted to show you. That's Opus page 10, I think. And lordships can pick it up from line 5. flicked over the page to line 10 of page 692. There is that, my lord, and then I would also ask you to look at Mr.
This wasn't in the specific context of selling properties, though, was it?
No, it wasn't.
It's the watch and the car.
Yes, yes. But I submit the principle should be the same. That it's,
Well, I follow that point, but there's also,
yes, your lordship's right.
was there specific evidence about that being alerted to that in relation to the properties? Because of course his business was property ownership, management, etc. And people who own properties quite often buy and sell them.
I don't believe there's evidence where the proposition was put to him that
No.
selling properties is something you should have identified as gambling. But
Yeah.
Well, isn't that a bit of a problem for this point? If this is something you say should have indicated that he was a problem gambler and undermines the judge's finding, should that not have been put to Mr. Wood?
I sold these properties, so it follows from that that he must not have known that it was not in the context of his property business.
well, my lord, I'm going to submit it's not.
Because he goes on to put, is this you or your junior? Counsel goes on to putting it neutrally. Counsel goes on to put the point about what the psychiatrist said about people lying and hiding the condition, which is a slightly different point, because Mr. Gibson did actually reveal that the properties that he'd bought, that he'd sold, and that he'd remortgaged. He may not reveal all of it, but it certainly appears to have revealed most of it.
Yes, I mean my submission is that that should have alerted Betfair to.
Yeah.
Okay. I see. Just Popplewell's point.
Right. So that's your fifth point.
That's my fifth point.
Your sixth point is a wrap up, isn't it? Really.
Is the wrap up of the evidence.
Take it all together, and you should have spotted that.
Well, I was going to take your lordships to the to some of the evidence. So perhaps I'll just give you a potted summary of the points I was going to make and the references.
Well, by all means, take us to it at 2 o'clock if you want. Why don't we do that, and then you're not hurried.
Very well.
Okay. 2 o'clock then, please.
Court rise if able.